Okay, class, hello. We're going to have your test today. This is going to be your 180 jury charge number 1. And so let me give you some proper names. You've got Orthonovum 150, and that's it, Orthonovum 150. Cap them both. This is going to be jury charge 180, number 1 for 5 minutes. Members of the jury, the preponderance or weight of evidence is not alone determined by the number of witnesses testifying to a particular fact or state of facts. You must not be governed or influenced by sympathy or prejudice for or against any party in this case. You are the sole judges of the credibility of each witness and of the weight to be given to the testimony of each. You should take into consideration his means of knowledge, strength of memory, and opportunities for observation, the reasonableness or unreasonableness of his testimony, the consistency or inconsistency of his testimony, the motives actuating him, the fact, if it is a fact, that his testimony has been contradicted, his bias, prejudice, or interest, if any, his manner or demeanor upon the witness stand, and all the other facts and circumstances shown by the evidence which affects the credibility of his testimony. In order for the plaintiffs to recover from the defendant on her claim for damages of the sale of a defective product, you must find all of the following have been established. 1. Defendant's oral contraceptive medication, Orthonovum 150, was defective in that defendant failed to adequately warn the medical profession and users of the risks of using Orthonovum 150, which risks were not known to either the medical profession or the users, but which defendant knew or should have known at the time its warnings and instructions on use were given, and that because of the inadequate warnings, if any, Orthonovum 150 was made unreasonably dangerous to a person who might reasonably be expected to use or be affected by it. 2. Plaintiff was a person who would reasonably be expected to use or be affected by Orthonovum 150. 3. Plaintiff sustained injuries and damages proximately caused by the defect in Orthonovum 150. If you find that any one or more of these 3 propositions has not been established by a preponderance of the evidence, then your verdict on this claim must be for the defendant. On the other hand, if you find that all of these 3 propositions have been established by a preponderance of the evidence, then your verdict must be for the plaintiff. A product may be in a defective condition and unreasonably dangerous to the user without any ascertainable defect or impurity in the product, and although the product was precisely what it was intended to be, if the manufacturer fails to give adequate and timely warnings as to dangers or side effects which may result from such product. To prevent a product from being unreasonably dangerous, appropriate and timely warnings concerning adverse reactions must be given. Some prescription medication, including defendant's oral contraceptive medication, Orthonovum 150, cannot possibly be made entirely safe for all consumption. Therefore, such a product is not defective and unreasonably dangerous if accompanied by adequate warnings of possible dangers and side effects. If the particular danger would be apparent to an ordinarily competent practitioner or user from the nature of the product itself, or from other information which an ordinarily competent practitioner or user could be expected to know, a warning thereof is not required. To be unreasonably dangerous, Orthonovum 150, because of an inadequate warning, must have created a risk of harm to users which a user or an ordinarily competent doctor would not reasonably expect, or must have created a greater risk of harm than a user or an ordinarily competent doctor would reasonably expect. In this case, the duty of the defendant to warn in connection with Orthonovum 150 is to be determined and judged by the state of medical knowledge and discoveries in existence a reasonable time prior to the date the plaintiff last purchased the drug prior to her clotting events. With respect to each prescription, you are not to consider scientific or medical knowledge or discoveries after a reasonable time prior to November 11, 1985. Proximate cause means a cause which, in natural and probable sequence, produced the claimed injury. It is a cause without which the claimed injury would not have been sustained. If more than one cause contributed to the claimed injury, then each cause may have been a proximate cause. A proximate cause in such circumstances need not have been the only cause or the last or nearest cause. Such cause is sufficient if it concurs with some other cause in combination with it or separately causing the claimed injury. A claimed inadequate warning or breach of warranty is not a proximate cause of plaintiff's injuries. However, if in order to bring about such injuries, it was necessary that such inadequate warning or breach of warranty combine or concur with an intervening cause, which also contributed to cause the injuries, but which intervening cause would not have been reasonably foreseen. Consortium consists of all the rights arising out of a marital relationship each spouse has to the person, affection, society, companionship, household services, aid, and comfort of the other spouse. A husband or a wife has the same right to recover for loss of consortium. The jury is not to infer from the fact that an instruction on measure of damages is given that the court is instructing the jury to assess or not to assess damages. The question of whether or not, and then you have your 180 number 2 jury charge, proper names. You have crime, this, valuable articles, giving false information, John R. Lake, United States, pewter, alexandrite, theft by receiving. And this is going to be 180 number 2 for 5 minutes. Members of the jury. The following is the statutory definition of a crime. This, a crime consists of a violation of a public law in the commission of which there shall be a union or joint operation of act and intention. A person commits the crime of valuable articles giving false information if he is a seller of a valuable article and knowingly gives false information in a written declaration to the purchaser of the valuable article. The elements of valuable articles giving false information are therefore 1, a seller of, 2, a valuable article, 3, knowingly giving for false information concerning length of ownership in a written declaration to 5, purchaser. If after considering all of the evidence you find that the prosecution has established beyond a reasonable doubt that the defendant, John R. Lake, acted in such a manner as to satisfy all of the above elements at or about the date and place stated in the information, you should find the defendant guilty of valuable articles giving false information. If you do not so find, you should find the defendant not guilty of valuable articles giving false information. Concerning the charges, in this case, certain words or phrases have a particular meaning. The following is the definition of these words or phrases. Seller means any person offering a valuable article for money to any purchaser offering a valuable article in full or part satisfaction of a debt, or offering a valuable article for resale for the purpose of full or part satisfaction of a debt. Purchaser means any person holding himself out to the public as being engaged in the business of buying valuable articles, or any person who purchases 5 or more valuable articles during any 30-day period. Purchaser does not include a person purchasing valuable articles from an estate or from a retail or wholesale merchant. Valuable article means any tangible personal property consisting in whole or in part of precious or semi-precious metals or stones, whether solid, plated, or overlaid, including but not limited to household goods, jewelry, United States commemorative medals or tokens, and gold and silver bullion. Precious or semi-precious metals or stones mean such metals as, but not limited to gold, silver, platinum, and pewter, and such stones as, but not limited to alexandrite, diamonds, emeralds, garnets, opals, rubies, sapphires, and topaz. For the purpose of this article, ivory, coral, pearls, jade, and such other minerals, stones, or gems are, as customarily regarded as precious or semi-precious, are deemed to be precious or semi-precious stones. A person committing the crime of theft by receiving a property valued at $10,000 or more is therefore 1, knowingly receiving, attaining, retaining, or disposing of any item of value of another with which the property of any other; 2, knowing or believing that said thing of value has been stolen; 3, with intent to deprive the lawful owner permanently of the use or benefit of the thing of value; and 4, the value of the thing involved is $10,000 or more. If after considering all of the evidence you find that the prosecution has established beyond a reasonable doubt that the defendant, John R. Lake, acted in such a manner so as to satisfy all of the above elements at or about the date and place stated in the information, you should find the defendant guilty of theft by receiving of property valued at $10,000 or more. If you do not so find, you should find the defendant not guilty of theft by receiving of property valued at $10,000 or more. In order to support a conviction of receiving stolen property, there must be proof of knowledge of the theft on the part of the recipient, which requires more than recent, unexplained, exclusive possession of the article or articles. This is not to say that recent, unexplained, exclusive possession is not a fact which the jury may well consider along with other evidence, either direct or circumstantial, of knowledge of the theft. It is merely insufficient by itself to prove such knowledge. If you find the defendant guilty of theft by receiving of property valued at $10,000 or more, you will determine by your verdict under the evidence and these instructions the reasonable market value of the property allegedly taken. A reasonable market value means the fair actual cash market value of the property. It is the price the property could have been sold for in the open market for cash under the usual and/or ordinary circumstances. That is, under those circumstances where a seller was willing to sell and a purchaser was willing to buy, but neither were under an obligation to do so. Value must be proven beyond a reasonable doubt, and you should not speculate as to the value. It is the defendant John R. Lake's theory of the case that he is not guilty of the charges of theft by receiving or giving false information. He at no time knew the ring in question was stolen and had every reason to believe that the same had not been stolen due to 2 police clearances. The only time he knew the value of the ring was after said clearance and when he was given $3,125 for the ring. Although he did sign the form in question, that was tough. And we'll get ready for your 160s. Number 1 test, you have proper names, state of Maine. Okay, state of Maine. Remember, you can write state of, S-T-A-O-F, with an asterisk. And then Maine is M-N with an asterisk. And that's it. You all 160 number 1 for 5 minutes. Members of the jury. There are 2 types of evidence from which you may find the truth as to the facts of a case. One is direct evidence. The other is circumstantial evidence. That is the proof of facts from which other facts may reasonably be inferred. The law makes no distinction between direct and circumstantial evidence. The evidence in this case consists of the sworn testimony of all the witnesses and presumptions stated in these instructions and all exhibits which have been received in evidence. You are to consider only the evidence in this case and reasonable inferences therefrom. An inference is a deduction or conclusion which reason and common sense lead the jury to draw from facts which have been proved. A crime is committed when the defendant has committed a voluntary act prohibited by law, accompanied by a culpable mental state. Voluntary act means an act performed consciously as a result of effort or determination. Culpable mental state means knowingly or willfully, as explained in this instruction. Proof of the commission of the act alone is not sufficient to prove that the defendant had the required culpable mental state. The culpable mental state is as much an element of the crime as the act itself and must be proven beyond a reasonable doubt either by direct or circumstantial evidence. A person acts knowingly or willfully with respect to conduct or to a circumstance described by a statute defining an offense when he is aware that his conduct is of such nature or that such circumstance exists. A person acts knowingly or willfully with respect to a result of his conduct when he is aware that his conduct is practically certain to cause the result. A person acts with specific intent when his conscious objective is to cause the specific result prescribed by the statute defining the offense. Specific intent is the state of mind voluntarily and willfully to do or to perform an act which will effect a certain result. Such an act must not be the result of accident or other innocent reason. The defendant's conscious objective must be to cause a certain result. It is immaterial to the issue of specific intent whether or not the result actually occurred. The elements of the crime of criminal mischief are: 1, that the defendant, 2, in the state of Maine, at or about the date and place charged, 3, knowingly damage personal property of one or more other persons in the course of a single criminal episode, and 4, the aggregate damages to personal property was $200 or more but less than $10,000. 5, with the affirmative defense of alibi in instruction number 11. After considering all the evidence, if you decide the prosecution has proven each of the elements beyond a reasonable doubt, you should find the defendant guilty of criminal mischief. After considering all the evidence, if you decide the prosecution has failed to prove each of the elements beyond a reasonable doubt, you should find the defendant not guilty of criminal mischief. The evidence presented in this case has raised the affirmative defense of alibi. The prosecution has the burden of proving the guilt of the defendant to your satisfaction beyond a reasonable doubt as to the affirmative defense, as well as to all the elements of the crime charged. After considering the evidence concerning the affirmative defense with all the other evidence in this case, if you are not convinced beyond a reasonable doubt of the defendant's guilt, you must return a verdict of not guilty. It is an affirmative defense to the crime charged that the defendant was not at the place of the crime at the time of its commission and that he was, in fact, at another place. This constitutes the defense of alibi. In order to clear up any doubts in your mind, the court instructs you further on the affirmative defense of alibi. When a defense is declared to be an affirmative defense, the defendant has the burden of establishing it by a preponderance of the evidence. Whenever an affirmative defense is raised, particular caution must be exercised to ensure that you, the jury, does not become confused. The defendant need only establish an affirmative defense by a preponderance of the evidence. This in no way diminishes the pre-existing and more pervasive requirement that the prosecution establish guilt beyond a reasonable doubt. It is essential that you, the jury, understand that the assertion of an affirmative defense does not detract from the prosecution's burden. To ensure that the prosecution's burden of proof is not diminished, guilt must be established beyond a reasonable doubt before you, the jury, may even consider the affirmative defense of alibi. The prosecution must, to convict, disprove it beyond a. And then we have your 160 number 2, proper names, City of Hope, and Maine. This is 160 number 2 for 5 minutes. And I think it continues from the last one, okay? Members of the jury, the evidence in this case has been completed. In a moment, I will read you the law which you must apply in order to reach your verdict. But first, I want to mention a few things that you need to keep in mind when you are discussing this case in the jury room. It is my job to decide what rules of law apply to the case. While the lawyers may have commented during the trial on some of these rules, you are to be guided by what I say about them. You must follow all of the rules as I explain them to you. Even if you disagree or don't understand the reasons for some of the rules, you must follow them. No single rule describes all the law which must be applied. Therefore, the rules must be considered together as a whole. During the course of the trial, you received all of the evidence that you may properly consider to decide the case. Your decision must be made by applying the rules of law which I give you to the evidence presented at trial. Neither sympathy nor prejudice should influence your decision. If you decide that the prosecution has proved beyond a reasonable doubt that the defendant has committed the crime as charged, It will be my job to decide what the punishment will be. You should not guess what the punishment might be. The punishment should not enter into your consideration at any time, nor should you allow it to influence your decision. At times during the trial, lawyers made objections to questions asked by other lawyers and to answers by witnesses. Do not draw any conclusions from such objections or from my rulings on the objections. These only related to the legal questions that I had to determine and should not influence your thinking. When I told you not to consider a particular statement, you were told to put that statement out of your mind, and you may not consider any statement in your deliberations which you were instructed to disregard. Finally, you should consider all the evidence in the light of your observations and experience in life. The defendant is charged with committing the crime of criminal mischief, damaging personal property of $200 or more but less than $10,000 in the city of Hope, Maine, on or about September 17, 1998. Defendant has pleaded not guilty. The charge against the defendant is not evidence. Every person charged with a crime is presumed innocent. This presumption of innocence remains with the defendant throughout the trial and should be considered by you unless after considering all of the evidence you are then convinced that the defendant is guilty beyond a reasonable doubt. The burden of proof is upon the prosecution to prove to the satisfaction of the jury beyond a reasonable doubt the existence of all of the elements necessary to constitute the crime charged. Reasonable doubt means a doubt based upon reason and common sense which arises from a fair and rational consideration of all of the evidence or the lack of evidence in the case. It is a doubt which is not a vague, speculative, or imaginary doubt, but such doubt as would cause reasonable people to hesitate to act in matters of importance to themselves. If you find from the evidence that each and every element has been proven beyond a reasonable doubt, you will find the defendant guilty. If you find from the evidence that the prosecution has failed to prove any one or more of the elements beyond a reasonable doubt, you will find the defendant not guilty. The mere number of witnesses appearing for or against a certain proposition does not in and of itself prove or disprove said proposition. You are the sole judges of the credibility of witnesses and of the weight to be given their testimony. You should take into consideration the witnesses' means of knowledge, strength of memory, and opportunities for observation, the reasonableness or unreasonableness of their testimony, the consistency or inconsistency of their testimony, the motive actuating them, the fact, if it is a fact, that their testimony has been contradicted, their bias, prejudice, or interest, if any, their manner or demeanor upon the witness stand, and all other facts and circumstances shown by the evidence which affect the credibility of their testimony. If you believe that any witness has willfully testified falsely to any material fact, in this case, you may disregard all or any part of his testimony. To constitute a crime, there must be the joint operation of an act forbidden by law and a culpable mental state of the defendant. Culpable mental state is just as much an element of the Okay, you all, so that concludes your jury charges. They were good, so hopefully you type one up. At least the 160s were good. Okay, have a great day, you all.